So nobody, if you're a landowner, or you are a purchaser of land, you cannot employ somebody to, go and guard the land. It is a criminal offense under the two laws. So after you've gone through your processes, you get what we call the abstract of title. The questions that your lawyer will be making, we call them the requisitions. And then in that one, they ask you to prove your title. Are there any encumbrances on the land? Whether the land there's a mortgage on it, whether it's a land that is co-owned. And then we'll come to that, whether it's co-owned between a spouse, spouses, siblings, because you inherited it under the vesting assent or the letter of administration of your father's estate, and then the surveyors will tell the adequate description of the land, with the plan that have been drawn and attached to it. And as I say, if it's from an estate, the vesting assent with the related issues. And then if it's a government land, the letter of consent. If it's a government land, you are requested to produce the letter of consent. And if it's a co-owned land, husband, wife, that one too, you are expected to produce how do you call it? Your consent. In fact, I may want to, especially with respect to wives, spouses. The section 47 talks about restriction on transfer of land by spouse. It's very, very important for us. So I may just quickly read it. Except as provided in subsection 3 and 4 of section 38. In the absence of a written agreement to the contrary by the spouses in the marriage, a spouse shall not, in respect of land, right or interest in land acquired for valuable consideration during marriage, sell, exchange, transfer, mortgage, or lease the land rights, without the consent of the, of the other. That's the law now. So I cannot sell our joint property. So it's very, very important. Once you do that, then all the section 43 to 45 talks about a voidable, it becomes a voidable conveyance. So the court can easily cancel the, whatever contract, whatever relationship that you entered into. I want us to quickly go through what we call the workflow of the land title registration, because that speaks for itself. So is it that the indenture has been prepared? And section 33, it's not because I'm a lawyer, but I'm just picking the section 33 of the law now, as it is now, that is only lawyers who qualify to prepare a conveyance. If I just this week, we're rushing, to prepare some documents. So we took, there are about 4 documents. After we had done the oath of proof and those, we took it to the Land Valuation Division of the Land Commission. And then they called us that we should come for the document. It's been queried. Because we don't have the lawyer's stamp and signature on it. Because in the past, people were, so many people who were preparing documents, they would just pick an old document. They don't even understand it, whether it's a lease, whether it's an assignment, and all those, and then they'll prepare it, and then give it to you, and you are happy, leading to a lot of litigation. So these are the issues involved in the indenture. The indenture could cover anything. Lease, transfers and all those things. And then there are what we call the implied covenants, and then on the part of the transferor, the person you are buying the land from, he has some responsibilities towards you. And you, the purchaser, you have some responsibilities. So even if they don't appear in the instrument, you are bound by them. It goes through. And then there's a question of the conveyance, very, very, very important. The person you are buying the land from, you see that, it would have indicated that, needs so and so, with the consent and concurrence of the principal elders of the, the family who have the right to do this and that and that, then he signs, and then in the presence of, those who witness for him. And then you see that from there, there's at the back of that document we have the oath of proof. And then the person who witnessed for them is, he is going to sign the deponent, and it's an oath. So that is why after that document has been signed, it has to go to court. So if you lie on oath, and now we have a similar problem on our heads right now with a member of parliament, allegedly, then you are lying on the oath. So it's perjury. So that's the process. After the court has done the oath of proof, then it goes to the land valuation division. You do your stamp duty, because that is covered by section 32(1)(2)(3) of the Stamp Act. That you cannot, no document, no instrument will be accepted until it has been stamped, and then you pay the adequate stamp duty on it. And then the Section 22 of the Land Commission Act also empowers the Land Valuation Division to do that. So after they've done the stamping and all those things, then you do your lodgement. At the time they are doing that, then they are doing the publication as well. The publication is to give notice to the whole world that they intend issuing assumancy with the land title certificate. So if you have any objection, then within 14 days, you have to raise the objection. If you don't, then that is the end of it. And that one too is covered by Section 96 of the new Lands Act. And as you go along, if there's a problem, multiple requests, I think the surveyor is going to talk more about it. Because that land, so this is an example, a typical example. You see that now the director of survey is writing to the director land title that he has requested them to prepare a cadastral plan or a parcel plan, but then there's a conflict. There's a conflict between the applicant and another person. In fact, this one, there was a problem there, in fact, because the grantor that they say is conflicting with the grantee. The grantor was the actual grantor. But the problem is that because there was a certificate on that land already, the document that was prepared, instead of them preparing a deed of transfer, they got a first registration application form. First registration with a lease is different from a transfer. So insofar as survey mapping is concerned, they have already plotted the land in Charles Dokuaku's name. So they cannot process that. But then, as we went along, there was a correction. So this is the letter that the land title director wrote to the director of survey that he should go ahead and then, prepare the certificate, because the problem has been resolved. And then as you go along, if there are any other problems, then somebody may raise an objection, what they call a caveat. The caveat under the law, section 134 and 136 of the Act. And then the caveat, it means after the publication, the person has an issue with the land. So he writes to raise an objection. That objection is what is called the caveat. And then the law says that within 7 days, the land title director should notify the applicant about that. Then they may refer it to, for resolution under the Alternative Dispute Resolution Act now, if you look at the law. That is section 98. Then if you are not able to resolve it, then they would, ask you to go to court. If you're able to resolve it as we did with the multiple request, then they will go ahead. And then another thing that we may want to, seriously look at is the Land Commission, the public vested that we were talking about concurrence. Because the law says that every stool land, if you are buying stool land or any government land, you need the consent of the Land Commission. In fact, it's a, Section 23 of the Act talks about it. Then it's a constitutional requirement, Article 258 of the 1992 Constitution, which established the Land Commission. So it said that there shall not be any disposition or development of any stool land unless the Regional Lands Commission has certified that the disposition, etc., is considered, considered with the development plan in the area, etc. So it is a constitutional mandate. So if you are acquiring any government land or any stool land, that is what, that's what happens. So these are, provisions that we may want to, look at when we go home. But Section 77, the Section 77, 79 do not form part of the land title registration thing we are doing. It falls under a new thing that is coming up. That is the Land Use and Special Planning Act 2016, Act 925. Now that law says that you cannot just get up and then, start building anyhow. You have to go through a lot of processes. The major thing I may want to draw our attention to is the Section 94 of the Special Planning Act. Change of use or zoning by these assemblies must be accurate and drawn to scale. And then if you are using the land for any other purpose than what originally had been planned for, you just don't get up. You have to. And today, in today's papers, in the same page, Ladadekotopon Municipal Assembly, public notice, application for change of use of site from commercial to residential. So if you want to, this person, originally the land was acquired for commercial purpose, but now you want to use it for residential purpose. So you have to, apply. And that's where the churches, we are very, very guilty. Because as you drive around, you see that a lot of land that, for residential purposes, we've used them for other purposes. In fact, blah, blah, blah. So on account of this, we request you to indicate the land use zoning of the subject site. So you cannot just get up and then build anyhow, because it is now a statutory requirement. So they wouldn't just, Land Commission, until you do that, they will stop processing your application for land title registration. Land Commission, that the public invested division of the Land Commission will not give you the consent that you require. Then the last thing I may want to touch on briefly is what I have titled the new trends in tax administration. The new trend in tax administration. Now, for whatever reason, GRA has become very, very overactive. I think the location and description of the property, your Ghana card, now when you are doing every application registration, they ask for your Ghana card. And then you see that you have your tax identification number, TIN number on it. And then the information should be supported with documented evidence, such as receipts, sale/purchase agreement. So you see that we are going back there. If you did not do a contract of sale, in which you have spelled out the condition, the terms and conditions, now they are asking for, all those information here when you apply for your land title registration. And if you don't do that, you don't pay your capital gain and you don't show it, Land Commission, does not continue the processing. So I think, in a nutshell, what we are trying to do, if you are lucky and you go through all those processes, then finally they issue you with your land title certificate. Then you can go home rejoicing because you have defeated Land Commission. Thank you very much.